Steve Wilkes in the San Francisco office of the Wagner Law Group. Welcome. Hope you all are doing well. Today's webinar, we're going to talk about collective investment funds, CIFs, CITs. The reason we're talking about it is that we have a lot of our clients and a lot of interest in this investment vehicle, both from the kind of the user side, from the investor side, and from the provider advisor side, and they are creatures of their own, with their own nuances and requirements. And I thought that we would give an overview today, reflective of our investment management practice, not only hitting on a couple of the ERISA factors, but talking about the intersection of some securities law and some banking law as well. So, I'll have a few introductory comments. We'll talk a little bit about some of the different regulatory regimes that are in play, a little bit about how they're organized, a couple of points on distribution and marketing, some compliance issues. I'm going to come back a little bit and talk about this strange, I don't want to say strange requirement of, they need to be, what does it mean to be maintained by a bank when most bank sponsors, if not all bank sponsors in turn, go out and retain on the sub-advisory level the actual advisor. How do you work that? And there's a few other factors about CIS. So I'm going to try to stick to our 30 minutes and appreciate your time. So here we go. What can we say? Collective trust funds, CIFs, collective investment funds, bank sponsored, they're very close to mutual funds. They've been around for a long time. And we see them in the defined benefit and the defined contribution plan marketplace. They're pretty competitive today, I think, nowadays with mutual funds and other pooled investment vehicles. And they've become a lot more mainstream, again, in the retirement plan world. There was a time when they were dominant back in the late 70s or maybe the very early 80s, pretty common. And during the boom of the 80s, mutual funds kind of overtook them for a lot of reasons, and one of the most important reasons was the fact that the kind of the administration, the platform availability for pricing and valuation, record keeping, it was a lot. There were some issues there, but they've come back, and they compete very well along all these categories. And I think the most important thing that people tend to say about these collective vehicles is that in today's world of looking so closely at fees and expenses, collective trust funds have a pretty good argument to make about their costs and their expense levels, at least when you put them side by side with some other investment funds, such as mutual funds. That's a general statement, which looks like it could be true. And there may be a little more flexibility because they're not regulated under the 40 Act, the way a mutual fund is. Maybe a little more flexibility as to how they do certain things, how they design the product, maybe access to some more diverse array of investments. So they're coming back, and depending on which survey you look at, they're really increasing in value. I saw a recent survey that said about 1.8 trillion. That's with a T. In collective vehicles. So that's a lot of progress. Typically, we used to see a lot of stable value type funds as kind of the basis for those collective vehicles, and now in this day and age now, as we turn the corner in the year 2000 and go into 2010 and now the next decade, obviously we see a lot of life cycle type funds, age-based funds, target funds, if you will, for the kind of the structure or style. So, like anything else, these are creatures of the devil's in the details, and there's a lot of opportunity in these funds. At the same time, there's the potential to get trapped. So I just wanted to talk about just some of the different attributes of these funds from a few different perspectives to give people a perspective, a little education on it, and see what we can learn from these. By the way, when I say, just so you know, when I talk about collective trust fund, again in the marketplace, a lot of times this is referred to as, they might be referred to as a CIF or a collective investment fund or a collective fund, but generally speaking, I'm talking about the kind of funds that are regulated by and kind of governed by the Office of the Comptroller of the Currency under its regulations, and those regulations, authorize what are referred to as common trust funds, or A1 funds in the business, or collective trust funds, which are what we're talking about today, and those are referred to as A2 kind of funds. A couple of statistics again. I talked about that trillion-dollar level before. Right now, most collective vehicles are, if you're in a national bank, you're going to be regulated under the OCC rules. If you're in a state charter bank, most states have mirror laws and regulations against the OCC. But the last time we looked, I saw some information for the year ended 2012, and it looked like the OCC was regulating about 1,500 national banks, about 750 federal savings associations, and a relatively smaller number of national trust banks. And about half of those institutions have asset management activities, which include fiduciary services and the ability to offer maybe a collective vehicle. So the OCC perspective, it's all about managing the risks. And when they go out and look at these funds, they're very focused on this, what's known in the industry as the rent-to-trustee issue, where the fund isn't really maintained by the bank, but an advisor just has a passive custodial trustee to sit in that role. So that's a little bit of an issue that needs to be structured from a legal point of view and engineered around. The OCC is very focused also on getting in and out of these funds too quickly, and what the admission fees and withdrawal fees might look like. You have some big name providers out there in the CIF world. BlackRock is huge, State Street, BONY, Mellon, Morgan, Wells Fargo, Wellington Trust Company, Invesco. Those are the larger names, I suppose. Hand Benefit and Trust down in Houston. There's some pretty significant players out there in this marketplace, and they provide a lot of opportunities. I think that we tend to see these vehicles are typically going into domestic and international equities. I'm looking at the last percentage. It's increased significantly from 2009 up to about 2013. The equity piece has actually gone up to close to 60%. By the same token, there's a little more acceptance and willingness to look at some alternative asset classes. So it's interesting the way the products are being developed. I guess in the market the last couple of years, people are very interested in looking for some alpha return if they can, and trying to square that with the notion of long-term investment retirement objectives. So there's a lot of players out there, a lot of assets, lots of opportunity. In terms of the regulatory, like who has an interest in these guys, who's in charge, I would say that it's one of the things that makes the collective investment vehicles a little bit difficult is that there's a lot of hands in the mix. You have as I mentioned before, you have the OCC from a banking perspective, and then if it's a state chartered institution, you have a state agency whose regulations typically mirror or mimic the OCC regs. You're going to have, the Internal Revenue Service, DOL, SEC, FINRA, and maybe the Commodities Futures Trading Commission, depending on the types of assets that are being invested. So, the thing about from an OCC perspective, these are the primary regulations that are touching on collective trust funds, and their regulations, if I could sum them up, I would say that they require that the bank has quote exclusive management of the fund, though they are able to make a prudent delegation. Funds have to be valued on a regular basis. Illiquid assets, maybe on an annual basis, subject to a good market, fair valuation. There are certain limits on management fees, and the funds are, are obviously subject to certain risk management requirements. And so that's the basic tenor of their regulations. They put out a lot of published guidance. If anyone goes to the OCC webpage, they have a lot of materials on OCC that are really helpful in terms of their asset management group and handbooks and guidelines. Really, really helpful. They put out some interpretive letters. They have a CIF handbook that deals with, asset management and conflicts and custody and all those kind of things. So they're a really good organization to work with in that regard in terms of, learning and accessing the rules. The DOL obviously is very concerned where retirement assets are going to be involved. Collective trust funds are subject to ERISA, and therefore the DOL has an interest in them. Because these collective funds themselves aren't registered under the, like mutual funds, they're going to be deemed, they will be deemed to be holding plan assets. The bank, any investment advisor to whom management responsibilities are delegated are going to be considered fiduciaries, and you have the whole world of prohibited transactions to keep an eye on, and various, reporting and disclosure requirements. Let me divert a little bit on ERISA. Basically, the look-through rule here is going to mean that, these plan assets, include an interest in every underlying asset. The trustee will be treated as a fiduciary. Some of the trust company personnel, might be fiduciaries. And this is because the trustee is, providing investment advice to plans and exercising discretion. And you can see that in, advisory opinion 96-15. Similarly, to the extent that an advisor provides advice with respect to the investment of the assets, they'll be treated as a fiduciary. So the trustee and the advisor to whom responsibility has been delegated are both subject to a pretty high standard of care. A lot of reporting and disclosure rules that we've talked about before, and the prohibited transaction rules, which can really, which are going to cover all the transactions. Some of them overlap, some are distinct. Depends on the line of business and how the fund is operated and structured. For example, if you have a statutory exemption 408B8, which exempts a plan's purchase of a collective interest from the bank, and it allows a trustee to charge additional fees for asset management without an offset. But this is conditioned on the approval of an affiliated fiduciary or approval written into the plan documents. And it's a good result, compared to mutual funds. And you also have considerations here, I think, under 404C, because if you have a plan that qualifies as a 404C plan, the fiduciary protection against personal liability, would extend to all the investment alternatives that are available under the plan, including any collective vehicles on the menu. So the fiduciary protection that's afforded to a 404C plan would be extended to a collective vehicle, and that's really valuable. But this protection is not absolute. There are various requirements that have to be met, so that's something that has to be looked at pretty clearly. There are a lot of other exemptions that potentially apply, and people look at, as I said, people look at 408B8 that I just talked about. You have to think about sometimes QPAM is going to be the right exemption for a bank or an advisor, for the fund sponsor or the advisor, depending on the nature of its activities. You have underlying concerns with the from just the tax treatment of the tax-exempt status of the collective trust and the group trust, which is important. Occasionally we see CIFs converted to mutual funds, and there's a class exemption for that, 97-41. Generally speaking, you have arm's length transactions are going to be governed by class exemption 91-38. And there are some special requirements there, like the plan's interest can't exceed 10% of the fund's assets, or the collective vehicle must invest substantially all of its assets in short-term obligations. So there's a lot of ways in and out of the ERISA maze there. Sweep services, overdraft protection. It just takes good structuring and good counseling up front to make sure you're working way around them properly. On the securities law side, I just want to say briefly that these interests are exempt under the 33 Act from registration, assuming that the fund is, quote, maintained by a bank. We'll talk about that a little later. and participation is limited to certain investors, qualified plans, pension or profit sharing plans, or a governmental plan. And also most of these, collective vehicles can avoid registration as a mutual fund under the Investment Company Act, based on the exemption found in 3C11, because that excludes, among other entities, collective trusts maintained by a bank, the assets of which consist solely of assets of, certain types of retirement plans. So another underpinning of that exemption is that the trust, that the collective vehicle that's relying on this exclusion must be maintained by the sponsoring bank. There's a lot of no action letters on this from the SEC, and the SEC has required that the bank must exercise substantial investment authority over the assets of the trust. Those are the magic words. Those opinions go back to 1991. The Provident Bank was the name of that no action letter. So a bank which is functioning just as a custodian or in a similar capacity isn't going to satisfy this maintained by the bank requirement. Having said that, the SEC knows that you can hire a sub-advisor or delegate, so there's whole art to structuring these advisory relationships and structuring the the way that the advice is delivered. I would also say that the collective trust fund interests themselves are considered exempted securities under the 34 Act, and they're going to be exempt from a lot of the reporting and disclosure there. That extends over to FINRA too, to the extent that a broker-dealer is involved in some way with introducing these or somehow making these available because they're exempt to securities. There's certain FINRA rules that will apply to to those transactions. Let me talk a little bit about the organizational structure. So anyway, that gives you a little bit of a feel. I mean, you have the DOL, the IRS, the SEC, a lot going on there. Let me talk a little bit about the structure and organization. Basically, you're going to have a sponsor, which is a bank, typically, as opposed to, mutual funds, which are sponsored by the advisor or an affiliate. We usually see a common law trust with the bank as the trustee. You can have trust documents and a declaration of trust, and these documents are going to provide for the establishment of the trust, investment powers, fees, all the provisions relating to the operation of the plan. You're going to see an agreement with each participating plan, participation agreement, disclosure documents, and then you might have some National Securities Clearing Corp type agreement, fund serve type agreement for electronic trading. In terms of the management itself, these could be managed by the bank itself, an affiliate, or externally managed. And the until recently, these collective vehicles, took fairly passive investment strategies, if you will. I think I mentioned earlier that stable value was very common back in the earlier days, but now it's really changed quite a bit. So you're seeing a lot of investment styles out there. Sometimes that creates an interesting issue in terms of valuation, because the banking rules require that fund investments have to be valued no less frequently than quarter. There's some other rules for real estate or for certain other illiquid assets maybe, or not as readily tradable assets that have to be valued at least annually. The thing though is that purchases and withdrawals have to be affected at whatever the current price is. So the bottom line is you need to have these things valued on a daily basis. That's the way most people like to. That's just the actual need of how they're going to work. There's some guidelines from the OCC on management fees. Can't exceed, they have to be reasonable, I suppose. Can't exceed an amount that's commensurate with the value of the services that are being provided, and that's something that's looked at closely. Distributions and marketing, that's you have to be familiar with and understand how to work on the NSCC trading platform. They've taken collective vehicles since, I think it was 1999 or 2000, 2001, right around there. You can purchase into the fund with cash or even in kind, but you have to think, that's where you have to think a little bit about some ERISA issues in case of an in-kind problem. Unlike a mutual fund, which really typically you don't see investor eligibility, collective vehicles are limited to, certain kinds of retirement plans. So that's a qualifier there. Then you can see some different rules on pricing flexibility. See different fees might vary by plan and what have you. You might have multiple share classes, things like that. In terms of, kind of distribution with broker-dealers, mutual funds go through the broker-dealer network. But at the federal level, these collective vehicles don't have to be sold through a broker-dealer. I would simply point out, to the extent that you do sell through a broker-dealer or make available through a broker-dealer, then there are going to be some FINRA rules that are available. I think it's Rule 0150 that relate to exempt securities, and those are some things that you're going to need to keep in mind. On the compliance side, basically there's increased scrutiny and a lot of compliance with with these programs. The OCC regulations require that banks have procedures written in writing, written policies and procedures that are adequate to maintain their fiduciary activities in a manner that complies with applicable law. That's similar to some, mutual fund rules. You're going to see exams from the OCC and at the state level, and they're going to review, when they come in and look at a bank, they're going to look at the collective trust fund activity as well. And the SEC also has just like the SEC has a program looking at mutual funds. I want to mention that, just come back a little bit to the this third-party advisor issue maintained by a bank. It's probably one of the kind of trickiest, or it gets a little nuanced. This requirement of being maintained by a bank, it makes it, it's a very unique aspect of collective vehicles. So I think it's interesting. So what this means is that an advisor that's hired to advise is going to have to kind of limit its power or authority. It's going to have to give up some of its authority to the bank. And for a long time, this was viewed as a bar for entry. A lot of advisors didn't want to do that. It was a disincentive. But now that there are ways to kind of work through that properly, legally, in compliance with the rule and the spirit of the rule, and advisors are finding, and we can help people achieve that balance just by the way that day-to-day operations are set up. So I think what's happening here is that the 40 Act, the Company Act, I should say, says that a collective trust fund has to be maintained by a bank, and it won't be considered an investment company for purposes of the Act. And they don't really, but there's really no definition of what maintained by means. And there have been some SEC releases and interpretive letters that help dice that apart. In 1980, the maintained by a bank requirement was discussed by the SEC, and they said it means that the bank has to exercise substantial investment responsibility. So therefore, a bank which was a mere custodian or acting in a similar capacity wouldn't, quote, maintain the asset. And there were a lot of no action letters that followed that allowed for banks to delegate a third-party advisor. But they still use the term substantial investment responsibility. So, this thing has evolved to the point where they kind of stopped. They put out a series of letters, and then they really stopped putting out any further interpretations on what it means. I think a lot of that. Well, for one thing, a lot of those letters and all that guidance was issued, in a different world. Before we had electronic trading and and the world, it just ran on a different technological clock than it does today, and compliance and surveillance are very different. The roles of advisors and sub-advisors have really changed. But I will say that the SEC, on the one hand, they've been silent about it, so we have these existing standards or guidance on the book. They've kind of come back out a couple of years ago, and they made a little noise in some public speeches and things that, as lawyers, we tend to hop on everything that we hear at these conferences and read in these newsletter columns. But they came out and they said they're a little concerned about, the use of collective vehicles I think that what they're really saying is that they're aware of this issue of managed by and the need to have substantial authority over, and they want to make sure that that element is satisfied so that the exemption is available. And it surprised a lot of people because they thought it hadn't been talked about for such a long amount of time. People thought it was kind of a moot issue, but the OCC has come back out, and the SEC has come back out with various bulletins and what have you. So I think that the current standard is that you can argue these things. We can argue them back and forth a little bit, but I think we have enough guidance from the SEC and the OCC at this point as to what maintained by and substantial authority over means to put people into a good place. In terms of so what does that really mean? What are some of the things that we're doing here? Some of the tools that we can use to kind of to work with the maintained by requirement. We have things like a process for pre-approving trades, establishing a list of permissible investments, providing or maybe providing certain persons of the third-party advisor to be designated as an officer of the sponsoring bank itself, and the ability to to review trades and to cancel trades at the expense of the advisor, things like that. So there's those are just several of the things that we can do to kind of work around the issue. So bottom line, where are we at? So these collective vehicles, we're seeing a lot more of them. They can be a great tool, a great product, a great service from the advisor-provider side as well as from the investor-user side. They're not subject to regulation under the 40 Act, which can be an advantage. By the same token, you have to dance through some hoops and be aware of some structural issues in terms of putting them together and structuring them. I would say that investment managers that are in the retirement marketplace, again, just need to be aware that these are very doable, but that the SEC and the OCC have an eye on these, and it's incumbent upon all of us to make sure we stay current on whatever published guidance comes out and whatever authority is out there, so that we know exactly where we stand. But at the moment, as a law firm, we work with a lot of collective investment vehicles, and we're very comfortable to give an opinion and to stand behind the structures and the policies and procedures that we put together. So there we go, 29 minutes. I hope that was interesting. If anyone has any questions about, I ran through a lot of different aspects of collective investment vehicles. If anyone has any questions or concerns or interest in any of these things, please let me know. We'd be glad to respond to you. I hope you have a wonderful Thanksgiving and holiday season. We're going to take December off, and our next webinar is going to be in January. I'm going to talk about performance advertising for investment advisors, and the reason I'm going to be talking about that is we're seeing a lot more of those issues come up. A lot of the investment advisors, especially the ones that are in the retirement marketplace, many of them have started on the platform of being advisors but not discretionary investment managers. We see a move toward exercising discretion as a way to compete and gather assets, and incumbent or along with being a discretionary manager, we're seeing plans or clients ask the advisor, well, what's your track record? If I'm going to let you run my money or pick investment menu, what does the performance look like? And as many of you know, performance advertising is very heavily regulated under the Advisors Act, and we're going to be talking about gross fees, net fees, hypothetical back testing, all those kind of things. So I will look forward to seeing you on January 22nd. Have a wonderful holiday season. On behalf of the Wagner Law Group, thank you very much for attending today.